exclusively handling this matter at the same time that they're trying to prosecute him and put him in jail. It's the same agency. Guess who had the blame game playing 24/7 initially? The Secret Service did.
They just tried to kill President Trump. You might want to make a note of that.
Well, we're already aware of it.
An injunction against Biden and Harris and their corrupt DOJ is what Ashley Moody from Florida is demanding. She's the attorney general there, and she says that the Harris-Biden administration is interfering and attempting to block Florida's investigation into the second assassination attempt of President Trump. Wonder why that might be. Now, we see this all the time in the movies where the feds roll in and they say, oh, it's our jurisdiction now. We're taking over this investigation. And, that might make sense in certain situations when you don't have a corrupt DOJ. But when this is happening here, Florida has an interest in making sure that their citizens are protected, and President Trump resides there and has a lot of property there. And so they're doing their due diligence as well, since the DOJ has seemingly been corrupt and neglectful over these last many years. So she released this, says we are now going to be demanding an injunction. They submitted a full filing here that we'll go through, but let's take a look at her press release. She says they filed a lawsuit in federal court against the DOJ over the DOJ's unlawful attempt to block Florida's investigation into the Trump assassination. They said that they're going to do their own independent state investigation to ensure that the state laws are being enforced, which is their right. Now, within days, however, the DOJ came in there and they said, you better suspend this. This is our jurisdiction. Now, they say the state of Florida has been clear. A dual track investigation would be in the best interest of all parties. It's not lost on us that the American people have concerns about federal agencies exclusively handling this matter at the same time that they're trying to prosecute him and put him in jail. It's the same agency. Now, given that the Department of Justice is preventing our independent investigation from proceeding, we filed a lawsuit to ensure that Florida can take appropriate action and enforce its laws. Now, after Florida announced that they would be conducting an independent investigation, Ron DeSantis signed Executive Order 24197 directing Florida law enforcement and their partners to investigate this and determine whether there were other state crimes that emanated from Ryan Ruth's actions. Now, as explained in the complaint that we'll read, they're saying there are multiple violations of items that they're allowed to do, and as reflected in the exhibits, the DOJ was impeding Florida agents, wasn't even giving them access to crime scenes. Now, they're explaining how the DOJ is misreading the law and why they are wrong. And so let's get into it. Florida versus Merrick Garland at the DOJ, demanding a declaration and an order against the DOJ for meddling and impeding their investigation into Trump. 18-pager filed in the Southern District of Florida, where we've spent a lot of time in other cases. But here is what the state AG says. All right, Merrick Garland. In just a 2-month period, President Trump has faced 2 credible attempts to take his life. Isn't that convenient? Now, in one attempt, a gunman fired shots at Trump's head, nearly killing him, and was even able to wound his ear. The alleged failures by the Secret Service with respect to that event were so severe that the head of the agency resigned right after she admitted they didn't retain any actual radio communications or other evidence that would show how this all went down, and bad. Now, in the other attempt, a gunman was able to hide for nearly 12 hours near the 6th green of the Trump International Golf Club in West Palm Beach, Florida. By the time the Secret Service found the shooter, he made it within several hundred yards of President Trump. So 2 days after the second assassination attempt, on September 17th, Ron DeSantis, the governor, signed an executive order, and that order directed Florida law enforcement partners to determine whether state charges should be brought. Within the days of the governor signing that order, guess what happened? The feds, FBI, under supervision by the DOJ, they indicated that Florida must suspend its investigation. Now, as the basis for this demand, the feds came in, they cited U.S. code, which purports to temporarily suspend state authority when the feds come in and investigate an assassination attempt. Now, in conversations with federal officials and in subsequent correspondence, these officials have stated that Florida may not conduct its own investigation, may not interview witnesses, and may only cooperate with the federal government's investigation. However, Ashley Moody, the state AG of Florida, says wrong. Because this section of the law actually does not prohibit our conduct, and because it would violate the 10th Amendment if it reached so far, Florida sues to vindicate its sovereign interest to investigate state violations of state law, as delay may impact the outcome of any prosecution. And the rights that are not enumerated and granted to the federal government are retained by the states. And they're saying we don't have that right anymore? Wrong. They say the parties here are the state of Florida, where Trump resides, Ashley Moody, the state AG, versus Merrick Garland, failed Supreme Court candidate and crybaby crybaby who doesn't like to be criticized. Jurisdictions in Florida, because Trump almost got shot there. Garland is the lead of the US DOJ, the Attorney General for the federal government. Now, we're in Florida because that's where this all occurred. Getting into the complaint, they explain from Florida. All right, on September 15th, President Trump played a round of golf at Trump International Golf Club in Florida. Now, during that round, the Secret Service discovered an armed gunman, later identified as Ryan Wesley Ruth, hiding near the 6th green. Secret Service agent fired at his position. Ruth fled on foot and later by car. Officers of Martin County Sheriff's Office, in coordination with the Palm Beach County Sheriff's Office, later located Mr. Ruth and took him into custody. Now, it is reasonably clear from all facts and circumstances, including a note authored by Mr. Ruth himself, that Mr. Ruth intended to assassinate President Trump. This was the second assassination attempt on President Trump in as many months. In the first attempt, a gunman was able to shoot President Trump in the ear and nearly kill him. During the first attempt in Butler, the Secret Service failed to discharge its duties in a variety of ways, including by allowing the gunman to access a rooftop with a clear line of sight to President Trump, and within days of these failures, the head of the Secret Service resigned, and then a few days later, they burned the body. With respect to the second attempt, similar concerns have been raised, such as how a gunman managed to get so close to President Trump and hide for 12 hours undetected and set up body armor on a fence. 2 days after this second attempt in Florida, Ron DeSantis issued an order, said, investigate this. Those charges may ultimately include attempted murder, fleeing and eluding, charges related to his unlawful possession of a firearm because he had multiple criminal convictions. As a convicted felon, shouldn't have had possession, so could have charged him murder under Florida statute there, 78204. Attempted crimes, fleeing and eluding, felon in possession, prohibited possession. Additionally, the state may pursue charges against Ruth stemming from injuries caused by his flight from law enforcement after the assassination attempt. Now, almost immediately, however, as soon as Florida started to look into this, federal officials began taking steps to halt the state's investigation. Stop looking into this. This was the guy who went back and forth to Ukraine. You remember that? Now, only a few days after Governor DeSantis signed the executive order, FBI agent in charge, Jeffrey Veltri, who hates Trump, as we've talked about here, called the FDLE special agent in charge, Florida, looks like feds called local in Fort Pierce. During that call, Mr. Veltri directed local law enforcement to U.S. code. He says, what do you think you're doing? He says, we're investigating state crimes. We have the authority to do that. He says, no, I don't think you do. He says, I think we do. Well, I'd like to direct you to U.S. code. He said, well, I read it. Oh, you did? Yeah, I did. Veltri, well, did you read section 351? Yeah, I'm looking at it. Well, look at section F. How about that? I'm reading it right now. Well, it says we have authority. That's not our interpretation, and I've got guidance from the state attorney general, Ashley Moody, something like that. Now, Mr. Veltri did so, even though at that time the federal government had only charged Mr. Ruth with firearms-related charges and didn't even charge him with attempted assassination. Now, this law purports to suspend the exercise of a jurisdiction where there is an attempted assassination, but that hadn't happened yet. And he says, so we're investigating ourselves. Get out of here, loser fed. Now, in a subsequent meeting between Florida's statewide prosecutor, Nicholas Cox, and U.S. Attorney Mackenzie LaPointe of SDF, Southern District of Florida, the U.S. Attorney again mentioned 351F. So again, they said, we haven't charged him with that. Now, in this meeting, U.S. Attorney LaPointe suggested that Florida should not interview witnesses until the federal investigation was completed. Well, maybe we are going to charge him with that, but we haven't charged him yet, so we're going to charge him. So don't investigate him because we are going to step in and then utilize this when it is right. So in light of these statements and other attempts to block Florida's investigation, then Ashley Moody, the Attorney General, says, hey, sends a letter back over to these people, U.S. Attorney, DOJ prosecutor, and the FBI director, and sends that in Exhibit 1. Says the letter covered several things. First, she tells the FBI the following. Says, you know, feds, there is a lack of public confidence in federal investigations. Now, the Secret Service and their repeated failures to adequately protect Trump, the federal government's ongoing prosecution of the victim, President Trump, they're prosecuting him in 2 different locations. They're appealing him. They raided his house, right? Well, we're going to make sure he doesn't get shot. Like, you almost shot him when you raided his house with armed FBI agents and had a use of force policy that authorized lethal force if necessary. That's why you raided him. I don't care if it's a form. It's still in the document. Now, the fact that Mr. Veltri, who is leading the investigation, hates Trump and has made statements in the past that some believe demonstrate a bias against Trump, which we've read here, hates the guy, posted a bunch of social media stuff. Now, the letter further noted that, quote, having Florida conduct its own investigation would mitigate public concern regarding the credibility and the reliability of these institutions. Would you be more satisfied, just ask yourself this one. With a report from local cops or from the federal agencies on this particular case? I think obviously we know the answer to that. It's an easy question. Do we have a reference for that? Of course we do. Yeah. It was the Butler shooting number 1. Guess who had the blame game playing 24/7 initially? The Secret Service did. Noted as a legal matter that general references to this section 351 in a verbal conversation were likely insufficient to invoke that. Okay. So like if you're going to come in here and steal our jurisdiction from us, you don't just get to say it flippantly in a voicemail. All right. Send something. The letter asked for clarification about whether 351 was being formally invoked. Are you seizing our jurisdiction? And if so, what you believe this provision prohibits and how the federal government would enforce it. So if you're stealing our authority to investigate this, since you're prosecuting Trump and you hate Trump and the special agent in charge also hates Trump, and this is the second time that the executive branch has allowed Trump to almost get killed, we would like to know what we're not allowed to do to investigate this. And if we do that, what are you going to do about it, Chris? Notably, when General Moody sent that letter, Attorney General from Florida, the DOJ had only charged him with illegal possession of firearms, which was initial, right? They needed to keep him on something, and so that's what that was. The DOJ had not charged him with any violation of Section 351. Now, after the DOJ received General Moody's letter, the DOJ then charged him with a violation of 351C, which prohibits the attempted assassination of a presidential candidate. So then on September 30th, a week after receiving Florida's letter, U.S. Attorney LaPont, so another prosecutor for the government, sent a response back to Florida. The letter from the prosecutor claimed that the federal indictment returned last week, which postdates your letter, resolves any potential uncertainty about whether this applies here. So she says, can you give me some clarification on the F? And F will say that if somebody's charged with these sections or something, then we have the authority. And so she says, well, I'm not telling you whether we're invoking this or not. We charged him with another subsection of this statute. And so therefore you can read into that what that means. However, she says, well, you didn't answer my question because you charged him with C. We're asking if you're invoking F. So U.S. Attorney LaPointe, the letter didn't provide any response to Moody and any guidance about F. What does it prohibit? Okay, if you're invoking this, does it mean I can't take pictures? Does it mean I can't interview witnesses? Am I allowed to get copies of evidence? What am I allowed to do? And if I'm prohibited from doing that list of things, what are you going to do if we do it anyways? So following this unequivocal assertion of F, the federal government almost immediately asked the trial court to assign to the criminal case to remove the case from the trial calendar until further notice. And it was unopposed. They designated this as a complex case. And so they continue. Here's the law. Section 351 prohibits the killing, kidnapping, or the assaulting of a variety of individuals. You see there's A, C, and E. Now, these individual members are people of Congress, members of Congress, certain high-ranking executive branch officials, justices of the Supreme Court, nominees for certain positions, major presidential, vice presidential candidates, all defined under the law. Now, Section F says, if federal investigative or prosecutive jurisdiction is asserted for a violation of this, like if you try to eliminate one of those people, that assertion shall suspend local authority until federal action is terminated. Suspend the exercise of jurisdiction. Now, it appears, says Moody from Florida, that no court has ever interpreted this provision. So what does it mean? But applying traditional principles and statutory interpretation, the statute is far narrower than the DOJ asserts, right? The DOJ is like, we're in charge of everything, so you can't do anything at all. Florida's like, yeah, right. Now, specifically, all the statute prohibits is the state's exercise of jurisdiction under any applicable state or local law until federal action is terminated. Now, the phrase exercise of jurisdiction, since no court has ever had to deal with this before, what does it mean? Well, it does not refer to all investigatory actions, okay? It refers to the formal exercise of jurisdiction over a person or a thing, which is namely a seizure. So in other words, we can investigate as long as we're not charging, as long as we're not arresting. First, the phrase exercise jurisdiction stands in contrast to the phrase assert jurisdiction, which is what the DOJ must do to trigger the statute. Now, given this contrast, exercising jurisdiction, which is what they're saying we are prohibited from doing, involves something more significant than asserting jurisdiction. For example, if someone asserts a right to vote, that person may take a number of actions short of actually casting a ballot, right? It's kind of broader. Well, I have a right, doesn't mean you actually are doing the thing. If someone seeks to exercise that right, however, that person may only do so by actually voting. So it's narrower. So in other words, we're only stopped from casting a ballot, but we're not stopped to having a right to cast a ballot, kind of an analogy. time. Now, second and relatedly, the phrase exercise jurisdiction is most frequently used in a manner consistent with Florida's reading of the statute, which means taking a person or a thing into custody. Exercising jurisdiction, in other words, arises most often in applying the rule of comity. Under that rule, when a state government and a federal government both assert jurisdiction over the same thing, the court, which first takes the subject matter of the litigation into its control, whether it's person or property, is permitted to exhaust its remedy to attain which it assumed control before the other court shall take it for its purpose. So we're kind of thinking of a case like a hot potato and passing it around. Now, in these cases, the first court to take custody of the person or thing triggers the rule, and they exercise jurisdiction over the person or the thing first to the person. Now, applying this understanding of jurisdiction grants the federal government a right to custody Mr. Ruth, even if the state arrests him first. In other words, the purpose of this is merely to modify the rule of comity, which would otherwise compel the federal government to wait for the state to prosecute and incarcerate Mr. Ruth before it could do so. They say, look, the state did arrest Mr. Ruth first, and they complied with this rule by acquiescing to the federal government. They gave Mr. Ruth to the feds. So finally, even if the state's reading is only one of multiple plausible readings, the court should adopt our reading instead. As explained, the federal government and their reading would raise a substantial question because it would render that section of the law unconstitutional under the 10th Amendment to basically say, well, they explain it in this next section. They say, the 10th Amendment to the United States says, the powers not delegated to the feds by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to us, we, the people. So if it's not explicit, if it doesn't go to the feds, this is not an enumerated thing that the federal government can do, or it's not prohibited, then it's reserved. We keep it. Now, that has obviously been perverted over the years. The government has given itself a lot more power at the expense. Things that were reserved to us have been absconded away from us and commandeered by our bloated, bureaucratic, disgusting federal government. But the point is, if they're saying, wait, you're also taking away from us the right to investigate, this is nuts. This amendment confirms that the Constitution confers on Congress not plenary legislative power, meaning they can't do whatever the hell they want, limitless. There's enumerated power, okay? It's explicit. You can do certain things. And then they say, well, but the Commerce Clause says we can regulate everything, including everything you ever touched in your life. And thus, all other legislative power is reserved for the states. Now, as is relevant here, the Supreme Court has interpreted the 10th Amendment to impose an anti-commandeering rule. Under that rule, the federal government may not command the state's officers or those of their political subdivisions to administer or enforce a Fed program. Unconstitutional commandeering can include ordering state officials to take some action, like conducting background checks. Now, the way they do this is with the power of the purse, okay? They just say, do you want federal money? If you want federal money, you're going to pass state laws that comply with our federal requirements. And then the states say, sure, because we still have to pay federal income tax, unless Trump gets rid of it, as there is conversation about recently, which would be absolutely incredible. Now, and it can also involve ordering state officials not to do something, right? Like, don't do these things. Now, commandeering, however, is different from federal preemption. Preemption occurs as a result of the Supremacy Clause, which says that in the Constitution, federal law is the supreme law of the land, unfortunately. But that clause is not an independent grant of legislative power to Congress. It simply provides a rule of decision. And when a federal law preempts a state law confers rights or imposes restrictions that conflict with federal law, the federal law reigns supreme. Now, the Constitution also confers upon Congress the power to regulate individuals and not states. As such, if it's valid preemption, it must regulate private actors. Now, by contrast, a federal law that dictates what state officials may and may not do is not a valid preemption provision and violates the anti-commandeering rule of the 10th Amendment, which means you're basically telling us not to conduct our investigation. So you're commandeering our investigation in violation of the 10th Amendment. Now, the mere fact that a state like us in Florida may not carry out our own right to investigate the violations of our own laws, that is a sovereign injury sufficient to trigger Article 3 jurisdiction in this court. But our concrete injuries go beyond that harm to our sovereignty. It's much worse than this. In fact, according to the federal prosecutor, U.S. Attorney LaPointe, Florida law enforcement officials may not conduct any investigative activities of their own until after the feds are done. Okay, so it doesn't mean prosecute, doesn't mean arrest him, doesn't mean subpoena him, issue search warrants. They can't investigate in anything until after they're done, once all the evidence is destroyed. This means, according to the federal government, the state may not interview witnesses, execute warrants, or subpoenas, do anything. Nothing. That is significant. Evidence disappears. Memories case fade. The state has no way to force the federal government to cooperate in the state's prosecution at all. So the feds come in, gobble up all the evidence, can't do anything until after the conclusion of the prosecution, and that's it. Every day that Florida is prevented from investigating, the state's case becomes harder and harder to prove at trial. By contrast, the feds have no injury at all. The state has no intention of interfering with or obstructing them. And so this is what we want. We want a declaration, and you're empowered to do this. Courts normally do not require plaintiffs to bet the farm, but the federal government here has demonstrated a genuine threat of enforcing this section of the law to stop the state of Florida from investigating the latest assassination attempt. As discussed above, they've told us in writing that this section of the law is in effect, and they've told state officials that basic investigative activities like simple interviews, making a subpoena for information, issuing arrest warrants, all illegal. Can't do any of it. Not just charging him, right, or making an arrest. He's already in federal custody. Maybe you could say charge him later or something, or charge him now and he's in federal custody, and that case will be put on hold until he's returned from custody. Many ways to do it, but they can't investigate anything is the point. Now, moreover, the federal government indicated in its letter it will not allow Florida to access the evidence until after the feds have concluded their own investigation. You only get it when we're done. But they say this law does not prevent that at all. In no way does it preclude the state from following this and investigating in their own capacity. The federal government dramatically overreads this section of the law. It merely modifies the traditional rule of comity, which allows the federal government to take custody over Ruth over the state, but we're still allowed to investigate this. And so we need a declaration to clarify whether the feds can lawfully prevent Florida and their team from investigating whether there were state crimes here. We also have another cause of action saying that they should be enjoined. Stop the federal government from interfering in our investigation, because enforcement of this, of anything that would prohibit us from doing our own investigation, would be illegal executive action. Count 3 is a violation of the 10th Amendment, saying the 10th Amendment operates directly on the states by leaving state law completely intact, is what they're trying to do. And here, at least on the DOJ's reading, it doesn't regulate private individuals at all, but they're regulating the state. They're saying the state can't investigate this. And even though we have the supremacy clause, it doesn't apply here, and they're encroaching on a state power. And so for these reasons, Ashley Moody, State AG of Florida, sends this one in, says they want to declare that Florida may conduct its own investigation without encroaching on the feds, or at least declare that section of the law unconstitutional, stop the DOJ and the feds from enforcing this section of the law that would prevent Florida from conducting its own investigation, and give us attorney's fees. Respectfully submitted by Ashley Moody, Attorney General, and the team over there in Florida. Great stuff to see them pushing back against the feds, because we know they can't be trusted at all. In fact, we are now hearing some 911 calls from their first incompetence, where the executive branch via the Secret Service and Homeland couldn't stop a shooter from getting on a sloped roof and taking shot at Trump's head. Here was one of the 911 call reports captured over from Fox.
Breaking news now. We have received more than a dozen 911 calls from the first assassination attempt on former President Trump. Remember, it was not long ago, that very first time. He's had an attempt since then. This time he was shot, though, and he survived during a rally in Butler County, Pennsylvania. I'm hearing this with you for the first time. Let's listen.
Me too, Harris.
We're at the Trump rally.
Yep, the police are on the way
Well, you
there.
better get over here quick.
We're at the Trump Assembly. As soon as the guy shooting the Butler Fair, it's getting shot up.
They just tried to kill President Trump. You might want to make a note of that.
Yeah, well,
Thank
we're already aware of it.
Yeah, you might want to make a note of that, the caller said. I want to remember now someone...
Pretty important day. And we remember that as well. Shocking day. It's still unbelievable that that happened. But hopefully the investigations are continuing on with some actual investigatory work happening from the officials who are looking into it. Because so far, it's been very strange behavior, even in Butler. As we saw, as Congress was forming their joint committee, they were torching the body and eliminating evidence, spraying off the blood from the top of the FBI building. All normal stuff is what they told us. Other people do not concur. So we'll keep our eye on that one. Thanks for subscribing, my friends, as we do.